The affidavit of service revealed that the required documents were served. The return of service referred to service of the petition only. As a result of these inconsistencies, the service of the required documents cannot be accepted and the petition has to be dismissed for these reasons. As regards the 8th, 9th, 10th, and 11th respondents, the application advanced and it was submitted by the court respondent that whereas the return of service only evidences service of the petition, the affidavits of service purport to state that the notice of presentation of the petition and of the nature of the security provided were also served. Because of these anomalies, it was urged that the petition has to be dismissed. Mr. Jeremy and Mr. Robertson, for the petitioners, argue that there is a presumption of regularity that the required documents were served. And in the judgment, I have detailed the returns of service. On behalf of the petitioners, it was urged that the evidence produced supports the presumption of regularity, which presumption has not been rebutted by any other evidence. They further submit that the provisions and rules of Chapter 104 do not require a return of service to be filed, and that this document is mere surplusage, which need not be considered. It was also submitted that the persons who went to effect service acted as a team. Mr. Mendes, for the 4th respondent, supported by the Attorney General, countered that the presumption of regularity cannot be applied, whereas here, service was effected by a non-state official. Reliance was placed on Benyon, on statutory interpretation, 8th edition, paragraph 7.6, under the heading presumption of correctness, and the case Guyana and Commission of Customs and another, a case from Jamaica, both the appellate and the Privy Council decisions. However, in my view, these authorities merely explain the general principles regarding the application of the presumption of regularity. They do not support the specific submission made. It was also submitted that the assertion that the petitioner and others acted as a team when they went to serve the required documents cannot be countenanced, and that the focus has to be on the exhibited returns of service and not the affidavits. I, however, note the submissions made by Mr. Khan for the 11th respondent that the operative document the court must rely on for proof of what documents were served is the affidavit of service. As such, as regards service on all the respondents except the 1st and 2nd, he accepted that the facts regarding service on the respondents is akin to the situation in the case of Melville. In the UC Guyana et al. And the Chief Elections Officer, a 1986 decision of Justice Pompey, His Honor held that the marshal's return of service cannot be used as a substitute for an affidavit of service. However, whereas in this case, a return of service is exhibited in support of an affidavit of service, it becomes part of the evidence to be considered. The petitioners cannot approbate and reprobate in this regard. Tender a document as evidence, and when it is found not to suit their interests, seek to abandon it. Therefore, all the evidence produced has to be considered in determining whether the respondents named were served or properly served with the required documents. It is tribe law that the rules as the service of elections petitions must be strictly complied with. In Williams and Mayor of Tenby, 1879, notice of presentation of the petition and the nature of security were not served. As a result, the petition was struck out. Justice Grove said, quote, "The question still is whether the provisions of the Act are or are not peremptory. I think they are peremptory, and that the terms not complied with are conditions precedent, which ought to be complied with before the petition could be presented. The appeal must be dismissed." In Payne, K. George, Chief Justice as he then was, stated at page 14 of the judgment, quote, "In my opinion, whether the service is effected by the petitioner or anyone on his behalf, the provision is clear. It requires the petitioner or his agent to file an affidavit of service. And of course, any such affidavit can only contain such facts as are within the personal knowledge of the deponent. This, in my view, would mean that the affidavit must be made by the person who effected the service or by someone else, including the petitioner or his agent, who was present when it was served," end quote. In Melville, there was a complaint regarding service. The affidavit of service stated that the required documents had been served by the petitioner, while the return of service by the marshal stated that he had served the election petition. Chief Justice Chang applied the omniprise muntur rule or principle of presumption of regularity to hold that the required documents were all served. He considered that there was no evidence to contradict the affidavit, that all the required documents were served, and that the marshal's return did not nullify the assertion in the affidavit. As highlighted in plain, either the petitioner or an agent could be the person who can file the required affidavit of service. Similarly, His Honor's decision also reflects that as distinct from the person who actually effected service, anyone who was present could swear to the affidavit of service. In Guyana, Justice Pompey held at page 9 that the statutory provisions do not require that the petitioner himself or herself effect service, with the provisions leaving it open in relation to the means by which personal service would be effected. His Honor further held that the affidavits must contain expressions of personal knowledge by the deponent about how service was effected. The affidavits of service sworn to by the persons who were present regarding the 1st, 8th, 9th, 10th, and 11th respondents reveal that the required documents were served. I have concluded that I would accept this evidence on behalf of the petitioners that the required documents were served on these respondents. I also accept the evidence as disclosed in the affidavits that the required documents were served in the first respondent, although Ms. Chan's return of service states that he served the election petition. Since in effect, the Section 8 and Rule 9.1 delegate the authority regarding service to the petitioner, then the court has to look to what the petitioner has done to determine if the statutory requirements have been complied with. If there is a prima facie evidence of this, then the court can presume that statute was followed and that the action taken was regularly done. I therefore treat the returns of service as Chief Justice Chang did, the Marshal's return of service in the case of Melville. I accept that the persons who went to effect service did so together and acted as a team, so to speak. To my mind, on the particular evidence in this case, the focus has to be on whether the required documents were served and whether they were served on the respondents personally. Importantly, unlike the cases of Payne and Melville, none of these respondents has complained that they were not served with the required documents. In my view, the focus should not be on who served them, though affidavits of service by someone who was present are required to prove that a particular respondent was served. As such, I do not consider that on the particular evidence of service of this petition, 99P 2020, that the application for the dismissal of the petition on the basis of improper service or non-service from these respondents has merit. I now turn to service on the second respondent. The issue is not so simple as regards service of the petition on the second respondent. As noted earlier, the initial affidavit of service deposed to by the second petitioner, Ms. Nurse, along with the affidavits in support of affidavit of service sworn to by Mr. Trevor Chan and Mr. Mark Roberts, were filed on September 29, 2020. These affidavits, which were all dated September 24, 2020, strangely stated that service was effected on September 25, 2020. An acknowledgement of service was exhibited, which is stated to have been signed by Mr. David Granger. Below the signature, it states, quote, David A. Granger, APNU plus AFC, 25th September 2020, end quote. As noted above, the required documents should have been served on or before September 21, 2020. Therefore, September 25, 2020 would be outside of the statutory 5-day period required for service. The petitioners in 99P 2020 concede that the affidavits of service assert that the second respondent was served on September 25, 2020, and that if accurate, it would mean that he was not served within the statutorily required time. Indeed, Mr. Jeremy stated that these difficulties appear regrettably on the face of the paper. However, subsequent to this issue being raised by the court and the applications by the court respondent and the Attorney General, without the permission of the court to do so, the petitioners filed supplementary affidavits on November 11, 2020 to negate the September 25, 2020 date and to explain that service was effected on the second respondent on September 18, 2020. The fourth respondent in particular objected to these additional affidavits on the basis that no permission was sought to file them, and that the filing of these affidavits on November 11, 2020, nearly 2 months after service was effected, violates Rule 9.5 of the rules, which provide that an affidavit of service must be filed as soon as may be after service has been effected. An affidavit that predates the activity to which it refers would not be acceptable as evidence of its contents. Apart from this, I have decided that the petitioner should not have filed the supplementary affidavits without permission of the court, more especially as the issue of late service was raised by the court on October 22nd, 2020, when the cases were first called for case management. Also, they were filed after the fourth respondent and the Attorney General would have filed applications to have the petition dismissed, with irregularity of service on the second respondent as a ground. Further, at this first CMC hearing, Mr. Robertson asserted that the service provisions had been complied with. In the circumstances, permission should have been sought before the filing of these supplementary affidavits. Therefore, these affidavits cannot be relied on as proof of the required timely service on the second respondent. In addition, I consider that even if accepted, the late filing of these supplementary affidavits would not be in compliance with the provisions of Rule 9.5 regarding the timeliness with which such affidavits are to be filed. I acknowledge that these supplementary affidavits of service were not filed some 10 months after the filing of the petitioners in Melville. Also, the petitioners have not delayed for as long as in Payne, where the petitioners filed a summons for extension to serve respondents over 3 months after the petition was filed. However, like the petitioners in the latter case. The petitioners, Ms. Thomas and Ms. Nurse, were aware of their default and should have moved speedily to address the issue. As noticed by K. George, Chief Justice in Payne, quote, tardiness is the very antithesis of the urgency and dispatch with which elections disputes are to be resolved, end quote. In Melville, Chief Justice Chan stated, quote, the prescription in Rule 9.5 that an affidavit of service is to the time and manner of service of a copy of the petition and of a notice of presentation of the petition and of the nature of security for cause must be filed as soon as may be after service has been effected in accordance with Rule 9. This underlines the importance which the drafters of the rules attached to the expeditious and timely hearing of elections petitions and to ensuring procedural fairness of those hearings to the respondents. Rule 9.5 speaks clearly to the need for the court to be made aware as early as possible as to whether the respondents have been in receipt of the core documents mentioned and whether the statutory prescriptions relating to service of the said documents have been complied with. If the affidavit of service has been filed, the court will be placed in a position to move towards the hearing of the petition, end quote. And also noted in Melville, the court has no jurisdiction to extend time for filing an affidavit of service outside of and as soon as may be after service has been effected time frame. Thus, as further found by Chief Justice Chan in Melville, the delay in filing the affidavit means that they are in effect non-documents. I conclude that there is a breach of Rule 9.5, and as such, there is no proof on this. There is no proof of service on the second respondent within the statutory timeline of 5 days after filing of the required documents. But even if the supplementary affidavits are accepted as evidence of service of the required documents on the second respondent, there is another fundamental reason why the affidavits cannot be relied on. I address this for completeness. The supplementary affidavits sworn to on November 11, 2020, and filed on the said date were deposed to by Ms. Nurse, Mr. Chan, and Mr. Roberts. Ms. Nurse swore as follows. That this supplementary affidavit is supplemental to an affidavit sworn to on the 24th day of September 2020 and filed on the 30th day of September 2020. That with respect to paragraph 3 of the affidavit of service sworn to on the 24th day of September 2020 and filed on the 30th day of September 2020, it was inadvertently stated that on the 25th day of September 2020, I, along with Trevor Chan, clerk to Mr. Mayor Robertson, attorney at law, and Mark Roberts, driver to Mr. Mayor Robertson, attorney at law, went to effect service on David Granger, the second named respondent of the hereunder described documents in this petition, which were issued out of the registry against the above respondents by the petitioners. That's to say, A, the petition and affidavit in support thereof sworn to by the petitioners. B, notice of presentation of petition. C, notice of security for cause instead of the 18th day of September 2020. That the error in paragraph 3 of the affidavit of service is obvious because it speaks to events that purportedly took place the day after my affidavit was executed. In addition, the exhibits attached to my affidavit were also stamped and marked on the day before the exhibit was purportedly created. That on the 18th day of September 2020, I served David Granger, the second named respondent. That on the 24th of September 2020, as I was preparing my affidavit of service, I realized that I did not have a signed acknowledgement from David Granger, the second named respondent. That I therefore went back to David Granger on the 24th day of September 2020 and requested that the second named respondent sign the acknowledgement sign the acknowledgement. That upon returning to David Granger, the second named respondent, I saw him sign and date the acknowledgement. I then took that acknowledgement to the Commissioner of Oaths to Affidavits and exhibited it to my affidavit of service, but unfortunately did not pay attention to the date placed on the acknowledgement by the second named respondent. That had I done so, I would have recognized that David Granger, the second named respondent, had incorrectly dated the acknowledgement of service, since I witnessed him sign it on the 24th day of September and not the 25th day of September, end quote. Mr. Chan and Mr. Roberts supported this narrative, stating that they had accompanied Ms. Nurse to effect service on the second respondent. However, while Mr. Chan stated that he inadvertently said service occurred on September 25 instead of September 18, Mr. Roberts swore that service was in fact effected on the 18th of October 2020. They nevertheless both swore that said David Granger, the second named respondent, signed the acknowledgement of service in their presence on the 24th day of September 2020. Section 8 of Chapter 104 provides for service of election petitions, and Rule 9 of the rules prescribe how service is to be effective, more specifically Rule 9.1. It is an entrenched principle of election laws that the provisions regarding time must be strictly complied with. This has been confirmed as early as 1879 in Williams and Tenby, which was cited earlier. This was also the decision by the Privy Council in Near and Tape, 1967. Non-adherence to the requisite timelines has been held by courts to result in the nullification of election petitions. In Ahmad and Kennedy 2003, the notice of the amount and nature of the security were not served within the statutory 5-day period. It was held by the Court of Appeal that such failure invalidated the petitions. Lord Justice Simon Brown held that timely service is an imperative in these cases. There is a plethora of cases from the English-speaking Caribbean which confirm that non-adherence to the provisions requiring service of all required documents within the statutory time allotted would result in the petitions being nullified and therefore dismissed. Some of these are Joseph and Brown, 1994, Prime and Nimrod, 2003, Mahabir and Coffey, 2015, Brown and Gibson, 1994, and Joseph and Reynolds, 2012. But I need only quote K. George, Chief Justice, to emphasize this point, which he made in Payne as follows, quote, the insistence on rigid adherence to the statutory provisions, whether it be as to the time for doing so or the manner in which an act should be done, is one of the peculiar and distinguishing features of disputes election laws. Not only is the time frame within which elections petitions should be filed considered a period of limitation and non-adherence fatal to its prosecution, but failure to comply with any of the other statutory requirements leads to a similar result, end quote. I have difficulty accepting the narrative of events as deposed to by the second petitioner and those who accompanied her to effect service on the second respondent. Even accepting an error in deposing to an event that was yet to occur, how is it that despite returning on September 24, the acknowledgement of service is not endorsed with this date, albeit September 24 would also be outside the period permitted for service. If service was indeed effected on September 18, on their return to Mr. Granger, great care should have been taken to ensure that this was correctly noted on the acknowledgement of service, given the importance attached to service of election petitions. Mr. Jeremy acknowledged that particular care should have been taken. It is also passing strange that having been served on either September 18 or 24, that the second respondent would acknowledge service with a date of September 25. Mr. Jeremy stated that in the Herculean effort to serve so many respondents, there had been things which have slipped. This is an understatement, to say the least. Such a slip or slippage is unacceptable given the stringency that is required in adhering to the rules for service of election petitions. The second respondent has not sought to clarify what occurred, given what appears to be his signature acknowledging service, which is dated September 25, 2020. And I must say categorically that the document exhibited as the acknowledgement of service by Mr. Granger is part and parcel of the evidence and cannot be treated as mere surplusage. Unlike the circumstances regarding service on the 1st, 8th, 9th, 10th, and 11th respondents, where I applied the presumption of regularity, the material inconsistencies disclosed cannot be countenanced. As held in Guyana at paragraph 59, the presumption of regularity only applies if there is no indication of irregularity. In this case, there are several indications of irregularity. Based on those indications, it would seem that the presumption of irregularity should not apply. Realizing the gravity of their obvious error, and it having been pointed out by the court on October 22nd, 2020, that service is out of time, the petitioners have sought to correct this error and have failed miserably. The evidence produced is manifestly unreliable and cannot be acted on to prove that the second respondent was served on September 18, 2020. The presumption of regularity, which the petitioners seek to rely on in relation to service on the second respondent, has been rebutted by the very evidence they have produced. This cannot be considered to be a technical preliminary objection as submitted by the petitioners relying on the dicta of Justice Martin in Stoddard and Prentice in 1898 decision. I have therefore concluded that the second respondent was not served within the 5-day period required by the rules for doing so. I turn now to consequences of late service on the second respondent. The issue then is, what is the consequence of this grave error? There are 11 other respondents who have been, or who by this decision, I consider to have been properly served with the required documents. Does this error in the service of the second respondent nullify this petition, or can it proceed against the remaining respondents? The 4th and 11th respondents, as well as the Attorney General, urge that it be nullified. In Payne, it was clearly stated or clearly held that service out of time is fatal to the validity of an election petition. The petitioners in 88P 2020 filed written submissions on whether the second respondent was a proper and necessary party, which the petitioners in 99P 2020 relied on. In addition, Mr. Jeremy made oral submission on this issue for the petitioners in both petitions. The petitioners argue that even in the unlikely event that the court were not to be persuaded by the petitioner's supplementary affidavits on the issue of the date of service, the untimely service on the second respondent, a party who was not necessary and or a proper party, is not an act that goes to the whole root of the petition so as to make the petition void. It was further claimed that it would be for the second respondent to establish that he is a necessary party and that the requirement of service with respect to him has to be met, and he was therefore not properly joined. Since the second respondent had not so asserted, then there was nothing that would prevent the court from proceeding with the adjudication of this petition. It was urged that Guyana, cited by the fourth respondent in support of his submissions, and in which section 4.2 was discussed, should not be relied on as the decision on the issue of who is a necessary party is incorrect or should be restricted to its particular facts. It was stated that the reasoning of K. George, Chief Justice in Payne, is to be preferred. I will consider these cases in detail shortly. Referencing the dictum of K. George CJ, it was submitted that the second respondent is not a representative of a list that is in conflict with the contentions of the petitioners. This is because one of the prayers for relief in both petitions is for, quote, an order that the chairman of the Guyana Elections Commission declare the presidential candidate designated on the APNU plus AFC list of candidates as the duly elected president of Guyana in accordance with Article 177 of the Constitution, end quote. In this regard, it was urged that this contention can be distinguished from the contentions in Guyana, which were not similar to the above stated prayer for relief. It was also submitted that this contention was not incompatible with the interests of the persons named in the list of candidates of which the second respondent was the representative. It was also stated that these petitions do not indicate contentions that are different from that of the second respondent. Mr. Ford also submitted the section 4.2 when compared with that of section 82 of legislation from India, that there is a difference in how these sections could be interpreted. Section 82 of the Representation of the People Act from India, as quoted in the submission, is quoted in the submissions. I won't read it out. It was noted that this provision, that's in section 82, which was discussed in Kamaraja and Tivar and others, the 1958 case. It was held in that case that the petitions were liable to be dismissed since the petitioners had failed to join as respondents candidates who the court found to be necessary parties. In effect, it was contended that the second respondent was not a necessary or proper party to the petitions. Thus, the joining of the second respondent amounted to a misjoinder rather than a non-joinder. Since he was misjoined, no adverse consequence would flow, as he is not a necessary party. Applying Payne, it was urged that such misjoinder was not fatal, as such a party can merely be struck out. Kumar and Singh was also cited, where it was held that, quote, if all the necessary parties have been joined to the election petition, the circumstances that the person who is not a necessary party has also been impleaded does not amount to a breach of the provisions of section 82. And no question of dismissing the petition under subsection 3 of section 90 arises. It is open to the election tribunal to strike out the name of the party who is not a necessary party within the meaning of Section 82 of the Act, end quote. It was also canvassed that as a consequence, no issue would arise regarding Section 27 of Chapter 104, though it was recognized that if the second respondent were a proper party and had issued notice of intention not to oppose the petition, he would not be allowed to appear as a party against the petitioners. In support of these submissions, it was asserted that, quote, consequently, the second named respondent and the other named respondents who are list representatives of the persons for whom no person named on those lists are elected to the National Assembly are not persons who are required to be served in strict compliance with the National Assembly Validity of Elections Act, Chapter 104, end quote. And it was also asserted that, quote, the joinder of the second respondent, as well as other respondents who are representatives of the list of candidates that were allocated any seats in the National Assembly, are not necessary and or proper parties to the election petition. Their joinder amounts to a misjoinder. It is further submitted that a misjoinder does not constitute a contravention of Section 4.2 of Chapter 104 and consequently cannot render the election petition liable to be dismissed, end quote. The fourth respondent, on the other hand, submitted that the second respondent is a necessary party and the proven improper service on him means that the petition is a nullity. Stabler and Solomon was cited where the Court of Appeal of Trinidad and Tobago held that due to the complaint about the conduct of the returning officer, he was a necessary party. Thus, failure to serve the petition on this returning officer resulted in the nullification of the petition. It was submitted that with the petitioners being electors so as to have local standard to institute the proceedings, their contentions would thereby affect the list the second respondent represents. It was stated that because there are allegations in 99P 2020 that both casts were invalid, this contention would presumably include both casts for the list the second respondent represents. This contention would appear prima facie to be one that conflicts with the interests of the list of persons the second respondent represents. Thus, even though the relief that is sought may work in favor of the second respondent, the point is that Chapter 104 focuses attention on the contentions in the petition and not necessarily on the reliefs sought. The point made was that the representative of a list is a respondent in election petition if any contention in an election petition conflicts with the interest of the names of the persons on the list arising out of the election. So it matters not that there may be relief which might favor the persons on the list, nor does it matter that there are contentions in election petition that might not conflict with the interests of the person on the list. Because the section speaks to any contention, as long as there is any contention in election petition which conflicts with the interests of the persons on the list, then the representative of the list is a proper and a necessary party to the proceedings. Applying Guyana, it was submitted that like the situation in that case, where the PPP lost the election, if the petitioners are successful in obtaining the relief sought, then even though the APNU AFC lost the elections, if the entire election is declared invalid, then it would lose the seats allocated and would be put through the trouble and expense of a new election. It was further advanced that the relief sought that relates to the other plea in the petition concerning the register of electors is the contention that the register of electors is invalid for a number of reasons. If such a finding were to be made by the court, it could potentially impact the voters who would have been on the list, who voted for the list the second respondent represents. Therefore, the contention impacts upon and conflicts with the interest of the list the second respondent represents, and votes cast in favor of that list. It was further submitted that the petition cannot be saved by merely striking out the respondent in respect of whom there has been non-compliance, for to do so would present a respondent with Hobson's choice. If he or she is successful in his complaint of non-compliance, the reward is removal from the proceedings, with the result that he or she is denied opportunity to participate in the important question whether the election was invalid or not. This is a case, in other words, where Hobson teams up with Pyrrhus. A victory on an application alleging non-compliance is secured at a high cost of exclusion from the proceedings. The Attorney General also submitted that while the petitioners sought relief for the nullification of the election, they also sought an order that the representative of the list be declared president from the very election they seek to invalidate. In this regard, it will be necessary for the second respondent to be a party, as the relief sought for nullification will be in conflict with that for a declaration as president. The fourth respondent and the AG submit that Justice Pompey was very clear that one cannot hear a case involving a party whose interest will be adversely affected by any inquiry by the court and by any orders made without hearing them. The 11th respondent adopted the submissions made by the fourth respondent and the Attorney General. Mr. Khan, for this respondent, added that if one seeks election by having one's name on a list and a petition is filed that seeks to upset that declaration, then ultimately this results in a situation of conflict. I now turn to the determination of the issue whether the second respondent is a proper and necessary party. The answer to this issue requires a consideration of Section 4.2 of Chapter 104, which I have outlined. It also requires an analysis of the cases of Payne and Guyana, which discuss Section 4, subsection 2. The Payne case related to the 1985 general elections. Here, several parties contested the general election of December 9, 1985, the results of which were declared on December 24, 1985. The petition was filed on January 23, 1986. The complaints regarding the validity of the elections were that it was not conducted in accordance with law, and in particular with the principles laid down in the Elections Regulations 1964, the National Registration Act 1967, and the Representation of the People Act Chapter 103, and that such non-compliance may be reasonably supposed to have affected the result of the said election. It was further complained that corrupt and illegal practices were committed in order to promote the election of members of the People's National Congress, that agents of this party's candidates were guilty of corrupt practices, and that the allocation of seats to the list of candidates that contested the election was wrong and contrary to law. Therefore, it was prayed that the court determined that the members of the People's National Congress were not duly elected as members of the National Assembly. Summonses were filed by a number of the respondents to have the petition dismissed on the ground of non-compliance with the statutory provisions regarding service as to the required documents and time frame. Relying on Section 4.2 of the relying on Section 4.2, the respondents also contended that there was a misjoinder of the 6th to 13th respondents, who were all returning officers, in circumstances where it was the chief election officer who would be answerable for any of their acts or omissions. While agreeing with the submission by the Solicitor General that these respondents should not have been joined, Chief Justice K. George held that he would have struck them out as they were not necessary. On the issue of who is a necessary party and the interpretation of Section 4.2, as noted earlier, the following passage from Chief Justice K. George's judgment was canvassed by the petitioners in preference to that of Justice Pompey in Guyana. This is what Justice George said. Quote, it must be noted that Section 4 of the Act requires the representative of a list of candidates to be made a respondent if the interest of any person named in that list conflicts with any contention in the election petition. Although two of the petitioners' contentions specifically refer to corrupt and illegal acts committed for the purpose of promoting the election of the 42 persons named in the People's National Congress list of candidates who were declared members of the National Assembly, and the prayer of the petition seeks a determination that they were not duly elected, there are two other contentions which can be said to be in conflict with the interests of those other persons whose names were declared as elected members of that assembly. And in this regard, I construe the word conflict in the section to mean not only a clash, but also an incompatibility with the interests of such person. That was the passage that was cited by counsel for the petitioners. However, counsel did not quote the entire paragraph of the decision. I do so now from pages 37 to 38, where His Honor further stated, quote, the complaints are that one, the election was not conducted in accordance with law, and such non-compliance may have reasonably supposed to have affected the results of the election. And two, the allocation of seats to the list of candidates that contested the election was wrong and contrary to law. If either of the above circumstances is successful, then it could affect the interests of some or all of the persons named in the other lists of candidates who were returned as members of the National Assembly. It is therefore my opinion these contentions can be said to be incompatible with those interests. Accordingly, in my judgment, all the representatives of the list that include candidates who were returned as members of the National Assembly should have been made respondents. And having been made respondents, it was incumbent upon the petitioners to serve them all those documents referred to in Section 8 of the Act, end quote. In Guyana, the petitioner prayed for orders that the said elections held on December 9, 1985 were not fair, free, and valid, that the result was affected by unlawful acts and omissions that allowed the People's National Congress to secure a majority of the seats in the National Assembly, that there would be a different placing of the respective lists of candidates regarding the allocation of seats, that election was ineffective and invalid, and that fresh elections be held. The respondents were the Chief Election Officer and Hugh Desmond Hoyt, representative of the list of candidates for the People's National Congress. These respondents filed applications to have the petition dismissed on the grounds of, firstly, non-compliance with the statutory requirements regarding service, and secondly, failure to join as respondents all representatives, including in particular Chetty Jagan and Marcellus Fielding Singh, of such list of candidates for election as comprise the names of persons with whose interests arising out of the elections held on December 1985, the contentions in the election petition conflict within the meaning of Section 4.2 of the said Act. End quote. The said Act, of course, is Chapter 104. Justice Pompey considered Section 4.2, and having noted that the second ground related to the non-joinder of necessary parties as respondents, had this to say, quote, it is very clear that the petitioners are seeking to declare the elections null and void and at the same time requesting this court, sitting as an election court, see the case of Petrie, to declare fresh and new elections. It is equally clear that in such an eventuality, that there is no guarantee that the same representation of seats in the House will result. Further, it is an accepted fact that the other representatives of the list, namely Chedi Jagan and Marcellus Fielding Singh, have not only taken up their seats, but have also participated in the business of the House. They have not sought to challenge the results of the elections. Petitioners maintain that the representatives of the list of the UF and PPP are not necessary parties to the petition, requiring their presence for determination of the issues raised therein. And further, nowhere in the petition is their conduct raised as an issue, nor are any of their seats challenged, and accordingly, the petition is not in conflict with the other two minority parties. If the representatives of the list of candidates are necessary parties to the petition, then they ought not to be excluded from the original petition, as Section 4 of the Act requires that they be made respondents if their interests conflict with any contention in the election petition. The petitioners, on the other hand, are insisting that there can only be a conflict arising if the petitioners allege a commission or omission of an illegal act against the PPP and the US, end quote. Having outlined the contentions of the petitioners as outlined above, Justice Pompey continued, quote, Section 4.2 of the Act not only refers to deeming the chief election officer and official as a respondent, but relates to anyone having conflict of interest of those other persons whose names were declared as elected members of the House of Assembly. If any of the above contentions is successful, then it could affect the interests of some or all of the persons named in the other list of candidates who were returned as members of the National Assembly. In this case, I understand and construe conflict in the section to mean in opposition to, disagreement with, or clash or incompatibility with the interests of such persons, in the words of the learned Chief Justice in the matter of Payne's petition. Further, should the court accept the contentions of the petitioners, it would be imposing a disability, an impediment on someone who is not a party to the proceedings. In the case of Lovering and Dawson, a candidate who lost his seat could not be a respondent as he had no seat to defend. In this case, the minority parties have seats in the National Assembly. His Honor further stated, quote, it is otherwise in this case in which the petitioners seek a declaration that the whole of the election held on the 9th of December be declared void. Further, if petition succeeds, the interests of the other representatives of the list with seats in the House appear to be prejudiced in three ways, namely, A, loss of those seats allocated to them, B, loss of the right to fill any casual vacancy by extracting names of the other members from the list, C, put to trouble and expense of a new election. With their absence, the court will be unable to carry out a meaningful inquiry, and it would be a breach of the rules of natural justice, audi alteram partem, should the court attempt to do so in their absence. See the Indian case of Singh and Scindia. Therefore, I am of the considered opinion that these contentions can only be said to be in disagreement or incompatible with the interests of the other representatives of the list. And I construe here to mean a mere dispute. It follows that all representatives of the list, which include candidates who just a minute. It follows that all representatives of the list, which include candidates who were returned and allocated seats in the National Assembly, should have been made respondents. In my view, their presence before the court is necessary to ensure that all matters in dispute in the petition might be effectually and completely determined. And it is incumbent on the petitioners to serve upon them all those documents referred to in Section 8 of the Act, end quote. Having so reasoned, apart from finding that there was non-compliance regarding the service provisions, Justice Pompey held that there was a failure to join the representatives of the list of the candidates for the PPP and the UF who were necessary parties. Thus, the petition in Guyana was struck out. Clearly from these decisions, both K. George, Chief Justice, and Justice Pompey, found that one had to consider the contentions alleged and the consequences of their possible success in determining whether there was a conflict with any of the interests of the list of candidates, more so those members who were returned as members of the National Assembly. For the purposes of this case, the second respondent would fall into the first category of respondent in Section 4.2. That is, as representative of such list of candidates whose interests arising out of the election, any contention in the election petition conflicts. It must therefore be determined whether the interests of the persons on the list that the second respondent represents are in conflict with any contention in the petitions. This requires consideration of the various contentions in the petitions and not solely a prayer or prayers for relief. I agree with the submission on behalf of the 4th and 11th respondent and the Attorney General that what is required is a determination that no contention is in conflict with the interest of the list which the second respondent represents. The 11th respondent canvassed an interest as contemplated in Section 4.2 requires not only that the representative of the list, refers not only to the representative of the list, but rather to the interest of every person named in that list. Thus, the contentions of the petitioners may affect and therefore conflict with any or all of the persons on the list, more so those who have taken up seats in the National Assembly and regional democratic councils. I do not agree with the submissions on behalf of the petitioners that Justice Pompey's decision cannot be accepted because he did not construe the word election in Section 4.2. For that matter, neither did K. George, Chief Justice, in Payne. There is no need to construe the word election, which appears 3 times in the subsection. The focus has to be on the contentions advanced in the petitions. In my opinion, Justice Pompey's decision, like that of Chief Justice George in Payne, simply states that if the petitioner succeeds, then the orders granted would affect the interests of the list of candidates who have been elected to the National Assembly. In this way, the interests of such list or lists of candidates would be in conflict with or incompatible with, and thereby prejudiced by the contentions advanced by the petitioner. Importantly, it is clear from Section 4.2 and the judgments in Payne and Guyana that this provision is meant to ensure that parties who contested the election are heard or given an opportunity to be heard. If they are not served or are not served properly and therefore cannot be heard, then the petition would be a nullity. The subsection encapsulates the audi alteram partem rule. That is, that interested persons or parties must be heard or be given an opportunity to be heard. I also accept that what has to be considered and determined is not whether one contention does not conflict, as advanced by the petitioners, inciting the prayer for declaration that the presidential candidate of the APNU and AFC be declared president, but whether any of the contentions conflict. Consider that the reasoning of K. George, Chief Justice, as quoted above, supports this view. There, His Honor found the 2 contentions were in conflict with the interests of those other persons whose names were declared as elected members of the National Assembly. To my mind, a careful reading of the decision of K. George, Chief Justice in Payne, confirms that it is any contention that has to be considered for determination whether it is incompatible with the list which the particular respondent represents. I do not find that there's any difference between the reasoning of Chief Justice George in Payne and Justice Pompey in Guyana. Indeed, Justice Pompey quoted Chief Justice George in coming to his conclusion. In this regard, it does not matter that the second respondent has indicated that no submissions were going to be made, quote, until the court fixes a date for trial. Thereupon, the second respondent will determine whether he will give notice of intention not to oppose the petition at least 6 days before the date fixed for trial, in pursuant to Section 27(1) of the National Assembly Validity of Elections Act, Chapter 104, and Rule 25(1) of the National Assembly Validity of Elections Rules, Chapter 104, end quote. Nor does it matter that he ultimately filed notices in both petitions indicating that he was not going to oppose them, pursuant to Section 27(1) of Chapter 104, albeit prematurely, as a date for trial has not been fixed in either petition. In any event, in order to so file, he has to be a proper party, and clearly thereby considered himself to be so. Though it is recognized that while one may consider oneself a proper party, a court may rule otherwise. Moreover, an indication that he's not opposed to the petitions does not remove the second respondent as a respondent. Once such a notice is filed, Section 27(2) merely provides that that respondent shall not be allowed to appear or to act as a party against the petition in any proceedings thereon. It does not say that the effect of issuing the notice is that the respondent ceases to be so. While the issue whether the contentions conflict with the interests of the second respondent are relevant to both petitions, in the context of whether petition 99P/2020 should proceed, it is the contentions of the petitioners in this petition which will be a primary focus. I will address the contentions in 88P/2020, though much more briefly. The contentions of the petitioners in 99P/2020, who deposed that they were electors for Electoral District 4 at the March 2, 2020 general regional elections, are many. They also deposed that they were employed as election assistants to Mr. Joseph Harmon, the statutorily appointed election agent of the APNU-AFC. I should note, however, that the fact that the petitioners were employed as election assistants to Mr. Joseph Harmon does not ipso facto mean that their contentions would not be in conflict with the interests of the list the second respondent represents. While at first blush, they appear to favor the list which the second respondent represents, a more nuanced consideration of the contentions has led me to conclude that indeed some of them conflict with the interests of the said list. Only a few of these contentions need be highlighted. In this regard, it is public knowledge that candidates of the list that the second respondent represents have taken up seats in the National Assembly as elected members of Parliament. By joining the second respondent, the petitioners must have concluded that the contentions they advance are in conflict with the interests of this respondent and the other 10 respondents who represent lists of candidates. Paragraph 7 of the petition, they contend that the elections were unlawfully conducted and or that the result of the said elections, if lawfully conducted, were affected or might have been affected by unlawful acts or omissions. More specifically, there are assertions regarding allegations of failings on the part of GECOM prior to and in the conduct of the elections of members of the National Assembly, for which elections day was March 2, 2020. These contentions can be in conflict with the interests of the list of the second respondent in that they raise issues that could affect the representatives of this list who are elected members of the National Assembly. Further, the contentions in the particulars or grounds which speak to the validity or invalidity of the electoral list are matters for which evidence would have to be advanced, all of which could conflict with the interests of the second respondents list, and indeed with the respective lists which all the respondents represent. The contentions regarding the validity and application or implementation of Order 60 of 2020 by GECOM and the invalidity of votes cast and or counted and recounted could result in a reduction rather than an increase in the votes and allocation of seats to the APNU AFC in a trial of the petition, a situation definitely in conflict with the interests of the list that the second respondent represents. In this regard, it cannot be presumed or assumed that the many generalized contentions and issues raised by the petitioners as anomalies and or irregularities in the conduct of the pre and post-elections process would be advantageous to the APNU AFC only. They may be disadvantageous, hence the necessity for the presence of the representative of this list as a party to the petition. Similarly, the many particularized contentions in which specific political parties represented by respondents, including the second respondent in this petition, are named as being potentially affected, indicate that they are all necessary parties. As regards relief sought, while the petitioners claim that the elections were conducted unlawfully and therefore should be nullified, they also seek an order that the chairman of GECOM declare the presidential candidate designated by the APNU AFC list of candidates as the duly elected president of Guyana in accordance with Article 177 of the Constitution. While these reliefs are seemingly inconsistent, the fact remains that the vitiation of the election would be in conflict with the interests of the list that the second respondent represents, more so as he was the said presidential candidate. Hence, in this regard, he would be a necessary party. The second respondent, because he was not served within the stipulated time, would not have had a chance to test the contentions and evidence which could affect the list he represents. In this regard, the reasoning and observance and observations of Justice Pompey are relevant, that having the representatives of the list of all who have been elected to the National Assembly before the court is necessary to ensure that all matters in dispute in the petition might be effectually and completely determined. The contentions also have to be considered in the context and against the backdrop of sections 29 and 30 of chapter 104, which permit the court to order a reallocation of seats in the National Assembly. Those who have taken up their seats are entitled to be heard as regards challenging any evidence led and or submissions made, and heard in relation to advancing a position as contemplated by section 27(1) that one does not intend to participate. If not served, or if service is null and void because there has been non-compliance with the service provisions, then the court would not have the benefit of hearing the case for the representative of such list or of an intention not to oppose. I have perused election petitions cases that have been filed over the years in Guyana. In all of them, the parties that secured seats in the National Assembly were always considered necessary parties through their representatives in elections petitions. The situation is no different in this case. Therefore, the submission that none of the parties who secured seats in the National Assembly should be considered a necessary party is preposterous, to say the least. Similarly, the seemingly opposite position also advanced is equally absurd, that those representatives for whom no person named on the list are elected to the National Assembly are also not persons who are required to be served. Indeed, these submissions appear to be inconsistent and beg the question, who could be named as respondents if these formulations are accepted? It begs an additional question, who would be a proper and necessary party? It is clear that these unmeritorious submissions were contrived to provide cover to the submission that the second respondent is not a proper and necessary party. Importantly, the elections are not restricted to national elections, which determine the presidency and the allocation of seats in the National Assembly, but apply to regional representation in the National Assembly, as well as to regional elections. Indeed, to exclude the representative of a list which commands 31 of the 65 seats in the National Assembly, and a list which has representatives on regional democratic councils as declared in the official gazette of August 2020, would be to deny voice to representatives of a large number of electors. Focus cannot be placed on the second respondent alone as a presidential candidate of the APNU-AFC, but as a representative of the list of candidates of these parties. He does not only represent himself, but thus I hold that the second respondent is a necessary party to the election petition 99P 2020. As a consequence, the late service of petition 99P 2020 on the second respondent amounted to non-service on him. This would lead to the nullification of petition 99P 2020 ab initio, more so as the court has to consider the status quo at the time of service and not the proceedings or positions of a party or parties adopted thereafter. This is to say, from the time petition 99P of 2020 was served out of time on the second respondent as a necessary party, it was a non-starter. The same cannot be said for petition 88P of 2020. The procedures in filing and serving this petition were fully complied with. Indeed, to permit 99P 2020 to proceed would be a disservice to the petitioners in 88P 2020, who ensured that they complied with all statutory requirements. This said, the petitioners in 88P 2020 deposed that they were electors in the March 2, 2020 general and regional elections. It is contended that the elections were not held in conformity with the Constitution, the Representation of the People Act, Chapter 103, and Order 60 of 2020, and should be entirely nullified. It is also contended that the Elections Laws Amendment number 15 of 2000 and Order 60, made pursuant thereto, are unconstitutional, so that the recount of votes process that was conducted and declaration of results made under the auspices of these provisions are void. Given that, as mentioned before, candidates of the list that the second respondent represents have been elected as and have taken up seats in the National Assembly as members of Parliament, these contentions conflict with the interests of these candidates who are on this list. These contentions conflict with the interests of the list the second respondent represents, since, as noted above, their ventilation may impact the number of votes and thereby the seats that each list of candidates, including that of the second respondent, may receive. Depending on the arguments advanced, as Mr. Ford telegraphed, that this petition will be prosecuted on the basis of legal submissions only, these candidates and the list can be adversely affected. As stated above, in finding that the Audi Alteram Partem rule applies, one should expect that apart from the petitioners considering that their petition is in conflict with the interests of the list of the second respondent represents, he had to have been given the opportunity to challenge whatever may be raised, which would be disadvantageous to or in conflict with the list he represents. If he chooses not to, then notice of such intention will be given pursuant to section 27(1) of chapter 1 of 4, as has been done. As such, I hold that the second respondent is a necessary party to this petition also. But in the absence of missteps, such as to nullify this petition, the fact that he's a necessary party, but is apparently choosing not to oppose it, does not affect the prosecution of this petition. As stated earlier, in order to decide that he would not oppose the petition, the second respondent has to be a proper party in order to exercise this option. Before I conclude, there is one matter I feel I should mention briefly. When one considers the contentions in these petitions, they are essentially no different from the contentions in Payne and Guyana. In Payne, as mentioned earlier, the contentions were that the election was not conducted in accordance with law, including the National Registration Act 1967 and the Representation of the People Act, Chapter 103, legislation about which there is contention in these two petitions. It was also complained that corrupt and illegal practices were committed and that the allocation of seats to the list that contested the election were wrong and contrary to law. In Guyana, the contentions were, as referred to earlier, that the election was not free, fair, and valid and was ineffective, that there were unlawful acts and omissions, and that there would be a different placing, and that there should be a different placing of the respective lists of candidates regarding the allocation of seats. The language may be different, the particularization of the contentions may be different, but they are essentially the same. And it is in the circumstances of these similar contentions that it was held in both cases that the representatives of the lists whose members were elected to the National Assembly were necessary parties. Therefore, as the petition 99P 2020, I declare that the petition is a nullity and cannot proceed for procedural non-compliance as the service of the said petition on the second respondent, who is a proper and necessary party. This petition is therefore dismissed. As regards cost, the respondents are, well, those who have appeared, I should be very careful with that, because some respondents have not appeared. The respondents are awarded costs to be taxed if not agreed. If costs are not agreed, the application for costs to be taxed is to be filed on or before February 26, 2021. The said application to be dealt with by the Registrar of the Supreme Court. Petition 88P 2020 will proceed and directions will be given as to the progress of this petition. Registrar, could I have my diary, please? While we wait on my diary to come, I can set some timelines now, Mr. Jeremy. Or Mr. Ford.
Lady, I've asked Mr. Ford to take the lead here.
Very well. What I know. Yes.
I'm here you. Sorry about it.
I know that Mr. Ford had indicated that this petition would be dealt with by submissions. And so I would seek now to make orders in relation to the filing of such submissions. Is that position maintained, Mr. Ford?
Yes, Your Honor, as I currently advise you.
If it pleases Your Honor, if I may be heard on that question.
Just a minute, Mr. Mendez. Yes, Mr. Mendez.
Much obliged, Your Honor. I have heard my learned friends submit in the past that there is no need for evidence in this case, and that therefore he was suggesting that directions be given for written submissions. Whereas to a large extent, a number of the matters that appear in the petition might not be factually in dispute. There may be other things that are factually in dispute, and in any event, so far as the defense of this case, the respondent that I represent wish to put before the court evidence which bears upon very important questions that the court may be called upon to deal with if you happen to be in agreement with the legal submissions that are being made. In thrust of the petition is that the order, order 60, that is the order for the recount, was a power that the commission did not have, or this put differently, the section under which that order was made is unconstitutional. That is a legal question that needs to be answered. We, of course, resist that, saying that the provision is not unconstitutional and that the commission did have the power to make the order. But in the event that you disagree with us, find that the commission did not have that power, the question would then arise, what do you do? And action law, including the provisions of the Representation of the People Act in this case, requires you to ask the further question. If indeed the order for the recount was unlawful, would it have made a difference to the election? And it's in answer to that question that it would be necessary for you to consider the evidence that is before the court. For example, I understand the petition to be this: if you find that the order for the recount was unlawful and therefore the recount ought not to have been held, then what you must do is to order that the Mingo, if I may call it that for short, the Mingo count must be implemented. In other words, the count of the statements of the poll that he has presented must be accepted, and therefore that the now opposition must be put into government. Of course, we will be saying that the court can't do that because the Mingo count is a fraudulent count. And therefore, we would want to put in a defense, as it were, to say, well, Mingo's statements Mingo's count of the statements of the board cannot be accepted by this court because it is a fraudulent count. And we would also want to say, in any event, that that there is evidence of what the true result is. And as it happens, that evidence is through the recount itself. So we would want to put before you the evidence of the recount that actually took place as evidence of what the result of the election should be. So all of this evidence would go towards the question whether the illegality, if you find that there was an illegality, affected the result of the election. So that what I was actually going to suggest is that you give the parties a short period of time to have a discussion as to what directions may be appropriate, so that we come back to you within 2 weeks' time. If we can't agree, of course, then, Your Honor, you would have to resolve that disagreement. But we were going to suggest that even though the rules don't actually provide, that we be given leave to provide a reply to the petition, so that my learned friends representing the petitioner would know exactly what we are intending to say, so that they would understand what issues we intend to raise. Therefore, they would understand what evidence they need to lead in order to meet the issues that we intend to raise. And then we can have a discussion as to exactly how that evidence is to be adduced before the court. That essentially, we disagree basically with my learned friends in saying that this is a pure issue of law, and therefore no evidence is necessary. But we would, in any event, we are entitled to say that. We are entitled to have a ruling from the court that this is not only an issue of law. So the directions would have to be given at the very least in order to make a determination as to how the court should proceed, having regard to our intentions. Again, I repeat, what I was going to suggest today is that give us a short opportunity of 2 weeks for us to have a discussion with each other and hopefully have an agreement on the directions which should be given at this stage.
Please, Your Honor.
Your Honor, sorry, go ahead, Mr. Knight.
May it please, Your Honor, I wish to join with learned senior counsel, Mr. Mendez, in supporting the application that has just been made I don't wish to reiterate all the issues so ably articulated by learned senior, but to say, Your Honor, out of an abundance of caution, and
Gentlemen, allow me to interrupt, please. I think we may have lost the court.
oh,
If you please, Your Honor, are you with us?
Mr. Jonas, we are hearing you.
might I
Yes.
proceed, Your Honor?
Thank
Yes,
you very much.
Your Honor, out of an abundance of caution, and in fact to assist the court, should the matter turn out the manner in which learned senior counsel has outlined, then we would need, Your Honor, to lay the evidential basis to assist the court in coming to the conclusion that we would like to persuade the court to come to. And that would require, Your Honor, the admission of the presentation of evidence in the form of affidavits and exhibits. And then, Your Honor, we are still also to work out, should evidence be called, if we provoke evidence, do we proceed by witness statement in light of the new rules, or do we go back to the traditional rules of 103, 104? So, Your Honor, I respectfully reiterate that date be granted to us, a short date, so that we can, of course, subject to Your Honor's overriding guidance on what should be discussed, but that we return to you in about 2 weeks with a timetable and a proposal on movement forward.
Good afternoon, Your Honor. Arud Gosai for the Guyana Elections Commission. While it is true, Your Honor, that the question will boil down to the interpretation of Order 60 as against the National Assembly Elections Act and the Constitution, there are multiple allegations, factual allegations against the Guyana Elections Commission, for which we will respectfully ask leave to answer those allegations prior to the court making any determination as to the lawfulness or otherwise of Order 60. So I join with learned senior counsel, Mr. Mendez, in the suggestion that we be granted respectfully and humbly a short adjournment, and we come back to Your Honor with proposed timelines in terms of answers or replies, whatever terminology Your Honor will use. But from the Guyana Elections Commission standpoint, we have to respond to those factual allegations, please, Your Honor.
Does any other representative, any other counsel for respondent wish to add before I go back to Mr. Ford? Very well. Mr. Ford, what do you have to say to the submissions by counsel?
Your Honor, what I wish to say is, firstly, I have looked at the National Assembly Validity of Election Act and the rules, and I can find no rule or provision supporting any of the submissions being made today on behalf of the respondents. Your Honor, the respondents did not file these elections petitions, or this election petition number 88, which is currently before the court. And I get the impression that you're somehow trying to determine what is necessary from the point of view of the petitioners to present a successful case before this court. Your Honors, there's no rule that has been cited, no provision that has been cited to support the program or the agenda of the respondents. In the circumstances, Your Honor, I don't see the purpose of adjourning for 2 weeks to have a discussion. Certainly, the discussion does not appear to be with the petitioner or counsel for the petitioner, but among themselves as to determine what they think should be done in relation to the petitioner's case for this petition, Your Honor.
Your Honor, I was indeed asking for the opportunity to speak to my learned friend. I thought I had made that clear. I would not be so rude as to suggest that the conversation would only take place among the respondents. If my learned friend, on the other hand, thinks that he is entitled to proceed without more, then, Your Honor, I would ask that that issue be determined preliminarily. In other words, that you receive submissions from the parties at this point in time as to exactly how we should proceed. Because as I stated, if this respondent intends to put forward a defense, which I have sketched out, and the question is, what procedure should be followed to allow the respondent to put forward that defense? I thought I was asking that we follow a procedure which was fair, so that my learned friends are representing the claimants would know in advance what we intend to say. I can't see that there could be any submission at this stage that we should be shut out entirely and not be permitted to put forward our defense. What I was suggesting is a procedure which would be fair to all, whereby the respondents could put forward whatever defense they wish to put before the court.
Well, let me ask you this question, Mr. Mendez, because I thought when you started off, you were saying that the legal issues that have been raised
Let's go.
in the petitions can be considered, and that depending on the ruling, there may be need for evidence. So I interpreted that to mean that we would take the submissions, or have the submissions filed by the parties, and so to be a two-pronged way of doing things, if it comes to that, that the submissions will be considered, and if it is, the court is of the view that the legal submissions of the petitioners have merit, then we would go to stage B. But if they're considered not to have merit, then there would be no need to proceed. So that is how I understood your submission.
Certainly, Your Honor, that would be one way to proceed. I wasn't actually suggesting that. I was suggesting that you hear everything together instead of splitting the issues, as it were. But we are in your hands, Your Honor. I'm not too sure, though. I would have to give consideration to it. I do not know what the Commission's position would be. Whether even if you were to consider the legal issues as a discrete point, whether you nevertheless would have to receive evidence. Commission may wish to put forward evidence before the court, because effectively what this part of the case involves is a challenge to the decisions made by the Commission itself. I would certainly want an opportunity to consider whether on that discrete point, we would need to put any evidence in. But I appreciate what you have said, Your Honor, that it is possible to deal with the legal issues only for the time being. And if they are decided against the claimants, well, that would be the end of the petition. If they are decided in favor of the claimants, then we go to the next stage, as it were. But I would just point out that then if we do it in that way, then you create a difficulty as far as appeals are concerned. Because if you were to reject their claim, if you were to reject the petition on the basis that they have no legal claim, and they appeal that to the CCJ and they succeed, then the case will have to come back to you to hear the second part of the case. So for that reason, there may be good sense to hear them together. But I just put that out. We would be happy to proceed along either course.
Well, Your Honor, if I may, the court just upheld the principles of audi alteram partem. And while I can't dictate or try to influence how Mr. Ford wishes to present his case, with equal force, Mr. Ford can determine how we lead a defense. And if Mr. Ford seeks to confine his case to legal submissions, then that's a matter for him. But if in my leading my defense, I wish to plead legal submissions as well as tender evidence, then that right is also mine. And I'm just,
Mr. Nandala, you're not being shut out with all due respect, because the court never said that you would not be entitled to put in submissions. So to say that the court just gave a decision and already altering part 10 and to suggest the court would not hear you, I consider that to be an untenable statement.
no, Your Honor, if I create that impression, I withdraw it immediately. What I wanted to say is that in fashioning my defense respectfully, Your Honor, I must have the fullest amplitude to be able to
Saying to you is you do not know, we do not know what submissions will be, that Mr. Ford will be making. So in my humble opinion, whilst I do appreciate what Mr. Mendez said, I think that I would prefer to have a bifurcated procedure, to have the submissions in, the court considers them without prejudice to the need to lead evidence if required. I do note that Mr. Ford indicated that there aren't provisions that speak to the leading of a defense. When I was going through the legislative provisions, particular chapter 104, indeed, it doesn't really speak to evidence being led, but clearly, respondents can be shut out. When you read the cases, it tends to suggest that evidence was led by both sides. If you read Esther Pereira, for instance, clearly evidence was led by and on behalf of the chief election officer. Of course, we are in a different time. In those days, one would have to take the evidence without witness statements, etc. So one doesn't get any advance preview. You don't even know who the witnesses are going to be called. Day by day, you're just hoping that each litigant will say, well, I have another witness, I have another witness. Whereas in a more case managed environment, one would say, well, you have to indicate how many witnesses you'll be calling, and you would have to produce witness statements for those witnesses, and one would not be allowed to have a roving commission to be calling 300 people and that kind of. So the more controlled environment, a focused environment. So I would want to think that we should go the route of having the submissions by the petitioners, that the respondents have an opportunity to respond to those submissions. And if it is that, having read the submissions, the matter cannot be concluded with those submissions, I will make the necessary orders for us to proceed.
Rama, I just have a question for clarification. Is it that these submissions touch and concern the constitutionality of Order 60? Because if that is so, it is going to hamstring the Guyana Elections Commission, because Order 60 sprang from a certain factual matrix. And so for GECOM to defend Order 60, there are certain facts that have to be before Your Honor. So I am not so clear as to what submissions exactly the petitioners are going to be advancing at this stage, and as to how GECOM will be able to defend those submissions or answer them without the necessary factual background. And I speak specifically, Your Honor, in relation to Article 162(1)(b) of the Constitution, which gives GECOM certain powers if it deems it expedient to do so. In this particular case, there are certain facts which led up to the making of Order 60. So even if Your Honor was minded to entertain submissions on the constitutionality of Order 60, there are certain facts which led to that order, which will prevent GECOM from answering properly without those factual matrices being placed before the court.
All right, maybe what I should do, and it's not jump the gun, let me reread petition 88. Because to be honest, my reading of it so far tended to suggest, I do appreciate what you've just said, Mr. Gusai, but my reading of it so far tended to suggest that legal arguments could have been entertained first. But I do appreciate what you said about the factual circumstances that would have led to Order 60. So, but you see, I don't want us to get bogged down in the evidential issues when the matters that are legal can be addressed upfront. Because, and it's not to shut out anyone, but if one gets into the factual issues, the evidential issues, then one would have to have a full-blown trial and bring witnesses in for cross-examination. Because it wouldn't be a situation where the affidavits could just be filed. And because I'm sure they would entertain disputes of fact. So one will have to address, even with your contention, Mr. Gosai, that GECOM had there's a factual matrix that led to the enactment, so to speak, or the publication of Order 60. The petitioners might have a totally different view. So that's just my concern. But let me reread the petitions, maybe Mr. Mendez's suggestion on some preliminary arguments, but then you end up with a lot of preliminary arguments on issues.
Your Honor.
Yes, Mr. Ford.
Thank you, Your Honor. Your Honor, I just wanted to point out that the issue of the unconstitutionality of Order 60 flows from Section 22 of the Election Laws Amendment Act, which the court will be well aware of. As far as I recall, Your Honor, the petition deals with the validity of that section as a matter of law. That is what I recall. The circumstances which would have caused GECOM to act or not act would be subsidiary matters. Whether or not GECOM has the power or not to do it is separate from the circumstances under which GECOM purported to exercise that power. Your Honor, I'm your initial position, Your Honor, I believe was fair in the circumstances, having regard to the nature of the case, because what I'm concerned about, Your Honor, and I think I have been mentioning this from time to time, even very early, even before we got to this stage of petition 99 being dismissed, that the two petitions should not necessarily go together. We are at that point where that has become almost inevitable. My concern, Your Honor, is that the respondents seeking to raise these sort of tangential issues, which are not germane or necessary to the determination of the issue raised in the petition. That was why I was asking and agreeing to Your Honor's position. I thought it was prudent that we put the submissions in and Your Honor then make any further determinations as you wish. I just wanted to say that.
Very well. I think I'm going to go the route of having the submissions and without prejudice to making any further orders. Or at least let us see what the submissions for the petitioners have to say. And if it is that they raise issues that, because Mr. Ford has just made an intervention that suggests that it's not so much an evidential issue as a very legal issue. So let me see the submissions on behalf of the petitioners. And if it is that they raise any issues that speak to factual dispute, then I will give the requisite directions. If not, we will just proceed and have submissions in reply by the respondents. I think that might be the better way to do it. So, Mr. Ford, I will now give you, I guess you are very ready with your submissions. So to give you 2 weeks hence, well, let's start to the 4th of February.
Your Honor,
Yes.
I'm just asking for a little additional time, please, Your Honor. We're asking for 3 weeks, please, Your Honor.
So, Mr. Ford, you should have been ready since August the 15th last year. Sorry, not the 15th. The end of August when you would have filed. Anyway, let me check. So today, no. All right, so February the 12th.
Thank you, Your Honor.
So we're at February the 12th. March the 5th for the respondents, including the Attorney General. Submissions in reply if necessary. On or before March the 19th. And we'll come back on April the 7th at 9:15. Of course, I will consider all the submissions. If it is that the court needs to give directions before that time, directions will be sent by email. So directions by email if necessary, because I would have had your submissions in, let me see, March 19th, yeah. So that if it is that I would be then alerting you as to whether the court would be going the route for requiring evidence or whether going the route for you to make oral submissions in support of your written submissions.
Your Honor, if I may bring another issue to your attention at this point. The Rule 19 of the rules deals with the production of election documents. And it provides for the making of orders by the court for the production and inspection of those documents. Then there's a proviso that says, provided the chief election officer shall, after the expiration of 12 months from the date of an election, burn all such documents and papers relating thereto. Now we are perilously close to 12 months since the date of the election. Having regard to the directions that you've just given, we will not get to the question of the production and inspection of documents until after the 2nd of March 2021, by which time, of course, the chief elections officer would then be entitled to burn the documents. So I'm asking at this stage that an order be made that the chief election officer produce all of the election documents and put them into the custody of the registrar of the court. so that if at a later date make an order that they be inspected, that they will be there available for such inspection.
Well, I'm trying to remember the name of the case right now. Mr. Ashton Chase, Senior Counsel, appeared. It went to the Court of Appeal, and the same issue arose that the time frame for the destruction of documents was either imminent or had passed. When you say produce the documents and put them in the custody of the registrar, my reading of everything, including petition 99, is that that's a voluminous lot of documents. What I would do is make an order that the documents not be destroyed pursuant to the legislation pending the hearing and determination of this case. Otherwise, I mean, I'm just going here anecdotally. I saw containers of documents at the at least on the television at the Artichon Convention Center, you know, to say to the registrar, those be put into the custody of the registrar. It would just be a notional custody because we're not going to bring them to the court, nor do we have any facilities to physically accept them. So I think that in order that the provisions of Section 90 not apply at this time until the hearing and determination of these proceedings.
This is you.
So I'll make sure that that is an order of court that will be served by Marshall on GECOM and the Chief Elections Officer.
Your Honor, if I may.
Yes, Mr. Khan.
As it relates to the order that the court has just made, which is in effect an order to preserve the status quo of the documents, would the court be minded to consider one particular set of documents to be held by the court? And I specifically refer to the statements of poll, which are only about 2,400 documents. I certainly appreciate the court's view that the rest of it would be onerous on the court. But as it relates to the actual statements of poll, I was wondering whether or not the court would be minded to have those documents lodged. They're only, like I said, they're 2,400.
So you have those documents
lodged with the registrar in accordance with the application made by Learned Senior, Mr. Mendez.
Well, you see, you were saying it's only 2,000 documents. I'm not discounting what you're advocating, but well, I guess the registrar could try to make some kind of arrangements as to where they would be stored. I'm just knowing where our physical capacity here at the court. And 2,000 documents.
That's a little under 5 reams, Your Honor.
Sorry?
It's a little under 5 reams of paper.
Very well. All right, I'll make that order. That's a good suggestion.
Just by way of clarification, Your Honor, I believe it would be statement of polls and the recount statement of recount as well.
Very well. So the statements of poll and the statements of recount are to be produced to the registrar for safekeeping. I'll perfect the order and the marshal will serve.
Thank you very much, Your Honor.
Most grateful, Your Honor.
Good. Thank you very much, everyone. And you will get these directions before the end of the week. And the order will be prepared for service on GECOM and the Chief Election Officer. Thank you very much. Registrar, you can adjourn the court.
Very good.
Thank you very much. Your Honor.
You.